Hi, I'm attorney Gregory Dell with the law firm of attorneys Dell and Schaefer, and I wanted to spend a few minutes talking about cognitive disorders or cognitive limitations. This issue has been coming up a lot lately in a lot of our cases, and the reason it's so important is because in most of the cases we're seeing with people who have cognitive limitations, the disability carriers are claiming that the claimant has a mental nervous condition or a mental health condition, and as a result, their benefits should be limited to a period of 24 months. And the reason they say the benefits should be limited to a period of 24 months is because there's a provision in most group ERISA-governed disability policies and some private individual policies that says if you have a mental nervous condition or a disability that's caused by a mental nervous condition, then your disability benefits will be limited to a period of 24 months. This issue gets very complicated because we represent a significant number of claimants who have cognitive limitations which are secondary to a physical injury. So let me give you a perfect example of this situation. Person gets in an auto accident, their head hits the dashboard, they lose consciousness for 10 seconds, 20 seconds, 30 seconds. Maybe they have an even more severe injury where they clearly have a head injury. As a result of that head injury, they end up having a post-concussive syndrome. They also have what's known as a minor brain injury. Now, I don't care if you call a brain injury minor, moderate, or severe. A brain injury is a brain injury. That's a physical injury. What results from that is that you have cognitive limitations very often, which means that you have difficulty processing tasks, that you have difficulty with short-term memory, you have difficulty with long-term memory. Your intelligence level is no longer able to allow you to process things as quickly as you once did. You're unable to multitask. You have difficulty doing numerous work activities that you once had to do. Now, can you function with your normal activities of daily living? Yes, you're able to bathe yourself, you're able to feed yourself, you're able to dress yourself, you're able to take yourself to the grocery store, you're able to drive a car. But does this mean that you're able to do any job that requires you to work 40 hours a week? No, not necessarily. And if you can't do your job and you can't work for 40 hours a week in any job, then clearly you should be eligible for disability insurance benefits. One of the best ways to prove, and probably one of the most significant and most credible ways to prove that you have cognitive limitations, is to have an exam performed by a board-certified neuropsychologist. Now, most neuropsychological examinations require a 2-day evaluation or an 8-hour evaluation. It depends how you're feeling on that particular day, and it depends upon how long the neuropsychologist is going to interview you and how long the testing, how many different tests the neuropsychologist is going to give you. The results of that will compare you to how thousands of other people have performed in the same tests that have been given to you. And based upon your results in that test, it will show whether or not you have any cognitive limitations. So what do you do when you get a positive test that comes back and says, yes, this person has cognitive limitations, and as a result of those limitations, they're unable to do their job? And now the disability carrier says, no, we think that's a mental nervous condition, not a physical condition. Well, that's obviously where our help comes in, and that's where we have expertise in being able to prove that these cognitive limitations that you are experiencing are secondary to the physical injury that you have. And if you're able to prove that the physical injury is truly what is disabling you and the secondary effects of that physical condition are cognitive, then you should be able to present a reasonable case to get over that 24-month mental nervous condition. Now, almost every week I'm seeing cases around the country that are going both ways. Some cases are saying, no, the cognitive limitations are caused by physical, therefore the 24-month mental nervous limitation shouldn't apply. And then I'm seeing other cases that are saying, yes, the limitation should apply. So it's very fact-specific in every single case whether or not we're going to be able to get over that 24-month mental nervous limitation. And the definition for the 24-month limitation is not the same in every single policy. So we have to analyze your policy. We have to look closely at your medical records. We have to see all of the support that you have to be able to beat this 24-month mental nervous limitation. Now, whether you're approaching that 24-month period or your benefits have already been denied, call us. because we want to prepare you if you're headed towards that 24-month limitation. And if you've already been cut off, we want to do everything we can to win your appeal or win your lawsuit to get your benefits reinstated. We always offer a free consultation, and we welcome the opportunity to discuss your claim with you.